Hi, so my name's Jay. I'm one of the co-founders of MyData Digital. Before I start, I just want to get a kind of a gauge of the room as to how you feel. There's a question up here, so if you can get screen.io up, whether you think loyalty programs are going to be disrupted by GDPR. And 1 for strongly agree, 2 for agree, and 3 disagree. Okay, whilst you're doing that, so quick bit of background, we set up MyData Digital in 2014 to rebalance the control of personal data between an organisation and citizen. We never set out to do GDPR. GDPR came along in 2016, and obviously because of its kind of core principles, just like the Data Protection Act, it really kind of underpinned what we were about as an organisation to redistribute that control of the personal data. So kind of ended up doing a lot around GDPR, understanding a lot, because if you're going to build a platform for basically citizens sharing their data or controlling their data with organisations, you probably need to understand all the intricacies of GDPR. But I'm still not an expert. There's lots of people on this planet who are. I'm not one of them. I've just got a good interest in it. And also my background, I used to work in big data, analytics, customer engagement programs, used to get heavily involved in loyalty. And it's really as I was kind of reading about data portability, I thought, this is really interesting because this could really disrupt the loyalty sector. So I strongly agree. It'd be good to see kind of how you guys feel at the end of this presentation. So just really kind of starting, just to kind of frame the discussion, I'm going to look at kind of these 4 areas. What are the key articles that I think are going to lead towards this disruption? What is the interpretation? Because there are actually a lot of different views, and there's no case law out there. There's different views as to actually how much data has been obtained, can be ported across, and so on. So I'm just going to look at that from a kind of a legal argument. Then you've got the interoperability piece, which is kind of essential if you're going to ship data between controllers. And then I'm just going to look at a couple of use cases at the end as to what that disruption might look like. So the 3 articles are obviously the right of access by the data subject, the right to erasure, I think could be quite interesting, and also obviously the key one being the right to data portability. So the right of access, we now have the right to go to an organisation to get effectively to do a subject access request, to find out why they hold our data, what purposes they use the data for, and so on. We also have the right in certain circumstances to have our data erased. Not in all cases. In fact, a lot of our clients are saying to us that they are actually causing more kind of customer dissatisfaction by the fact that they've had a couple of people say, can you erase my data? And they actually go back and say, well, I can, but not all of it. And it frustrates them. So it's interesting that people it'd be easier if people could kind of delete some of their data or not all of it, and actually through our system they can actually see very clearly what data they can delete and what data they can't, because we allow the kind of 6 lawful bases be applied to each purpose. And then there's the big one, which is the right to data portability. So we have the opportunity to transfer our data to another controller that has been obtained by the controller about us. And obtained is kind of an interesting term. And the reason why it's an interesting term is because there's kind of 2 views on what this obtained means. What it doesn't allow for, and I should probably just note, is under data portability, any data that's been inferred is actually considered as IP and therefore does not have to be ported across. But there's this view of a restrictive view, and that is kind of any data that I've given the organisation. So in a classic case, forms I've filled in. So some lawyers might argue semantics and say, well, did they obtain it from you? Yes, but obviously also the other bit under portability, it clearly states that it's any data that's been collected under consent or under contract. And when you look at kind of consent, you have to consent to give up your GPS data, your cookie history, and so on. And because you've consented to that, therefore they've obtained it from you. And that means that really the view is that the extensive one is a much greater kind of quantity of data. It obviously puts a lot more pressure on the data controllers when data portability actually gets kicked off. And probably I should say that, talking about data portability, I don't know about you guys, but in terms of certainly our clients in the UK, I think they all completely have missed data portability. None of them are prepared for it. None of them actually know that it's kind of coming. Data portability is effectively what the banking sector or financial sector and the energy firms had kind of dropped on them through regulation. It's effectively, that regulation through the back door to every single sector across, the EU have now got to make their data portable. So, in terms of kind of where it ended up, recital 68, I won't go into all the details, actually kind of infers, because you're getting back to what the regulators wanted to do through the recitals, was actually to kind of any data much broader that has been collected about an individual by the organisation. And then Working Party 29 actually have made it a lot easier for us, because they've come out and clearly said our view of the articles is that it is the extensive version, it is any data that's been obtained, so it's your play history on Spotify, it's your shopping transactions through Amazon, any data that's been obtained, cookies, etc. So when you look at it like that, I'm starting to think, oh, hang on, this could be interesting from a disruption point of view. Now, I know there's lots of different tracks on this, and interoperability is a key piece, because obviously it's about, when you look at the very first draft of GDPR was actually suggesting that they wanted to have a common format for the transmission of data. So the first draft of GDPR, really the regulators wanted to have a common standard for transferring data between controllers. And I think that's really cool, because it shows that the regulators were kind of there thinking, how can we have, a connected society? So, my view is, as a citizen, I could kind of raise a portability request to an organisation. It'd be in an interoperable format. I could then pass it across to another entity. I could actually tell them, here's the data, you can use it for this purpose, and so on, and then let them use it. That would be really cool. Our platform can do a lot of that already. But kind of this is what we ended up with. So, and it even goes as far as, you only have to provide it in a machine-readable format where technically feasible. So it's kind of, because obviously like all things, we all set out with kind of good intentions, and then we have to look at the practicalities of actually making things happen. And I think had GDPR insisted that interoperable standards were used, I don't think it would have ever been possible to implement it, certainly within the timeframes that they were putting forward. So that's kind of the background that got me thinking, how can programs be disrupted? And I'm just throwing out some ideas. You guys might think these are ridiculous, okay? But I'm just looking at kind of how I think loyalty could potentially be disrupted, and I think it could be disrupted in a kind of anti-competitive way for some organisations, and I think it could be kind of used to actually enhance loyalty programs as well. I'm not just talking about kind of disrupting them, but actually the enhancement as well. So this is one idea. This is a kind of a personal thing. I used to fly to the US a lot, and it was kind of just prior to Virgin Atlantic and Delta kind of doing a merger or an acquisition, and they started changing all their flights, and it became really annoying for me, and I couldn't get to the locations I wanted to really easily. The problem was I was flying a lot, so I had a lot of status with Virgin Atlantic, so I was treated pretty well. And I didn't want to, well, I wanted to use BA flights because they were far more convenient, closer to home. I could get to the cities I wanted to get to. The problem is, they wouldn't actually accept my my phone call to say, look, I'm a really common flyer, frequent flyer, we do it. Well, we need evidence and so on. I said, well, I can, just do your screen grab off. Well, no, that won't work. We would need the data. So I was thinking, here's an option. So if I was to request my data from Virgin Atlantic, which clearly would have been collected under contract because a transaction would occur, I paid money and so on. They would therefore have to give me all of my loyalty data, all of my flight history and so on. I could effectively collect that and then I could pass it across to British Airways. British Airways take my data. Ideally, they might confirm my status and actually say, we're happy to offer you the status without having to do it. We can see you're going to be flying low, so you can just come straight on in. And then on that, I then have to raise an erasure. Now, I'm sure they would not be allowed to erase my flight history, but they may be able to erase my connection to the loyalty program, and therefore I lose my status. And the erasure request is confirmed. You can tell I've just left my thing, and I disappear off their system. And now I'm working. So whether that would ever happen, I'm certainly not going to build that program, and who's to say the airline probably go, I'm never going to do that, because if I did it, then the other airline are just going to do it to me, and so on. So I'm just kind of showing where I think things could happen. More interesting, though, is I think had we gone to interoperability, and we're seeing parts of this already, I just don't think large organisations are looking at interoperability as a way of actually enhancing the services that they can offer to their customers. So I thought I'd use K Supermarket being a Finnish supermarket. What I'm thinking here is, if interoperability had occurred, I could request my order history from my K Supermarket, and then I could actually share that across to FitnessPal for the purpose of giving me recipe recommendations based on the products that I've been purchasing. I could then actually pass back my lifestyle data, what I'm looking to achieve, my fitness goals and so on. That could then be pushed back to K Supermarket, into their loyalty program, and they could be making product recommendations to me based on my lifestyle. That, would be great. And okay, we're obviously seeing elements like that today through apps being connected together, but I'm not really seeing any retailers or loyalty programs really taking advantage of connecting things together. And I think, we should be encouraging data portability across organisations, because I think it can enhance services. So that's, I just wanted to kind of throw out there a kind of a quick view why I think it can happen. The regulation is there to actually make it happen. I just think a lot of organisations are keeping very quiet about it because they know technically it's going to be an absolute nightmare for them. And I just don't think citizens are anywhere near educated enough to actually understand what their rights are under GDPR to actually decide that they want to photocopy their data to another controller. I mean, most of them think, why would I want to do that? And therefore, I encourage everyone in this room to kind of be out there talking about it and getting organisations to kind of see the opportunity, because I think there's a great opportunity there. So thank you. Any questions?